The judge thought it was a routine evictionant. Until a hidden lease suddenly appeared, signed by both sides. In that moment, the entire case flipped, and the courtroom went silent as the judge realized he might have no power to rule at all.
HP Foreclosure Solutions versus All Occupant. This is a termination. This is a motion.
This is Cheatham's motion to set aside a default, Judge, for what it's worth.
Did you get a copy of it, counsel?
I had to ask the court clerk, and they were gracious enough to email me a copy. Yes, I did.
All right, very good.
Thank you for asking.
Ma'am, what is your position on why I should set aside this termination?
I did not see the court document to come to the, what am I saying? Okay, so I did not receive in the mail the court date until like 3 days after the court date.
Okay, let me explain a couple things.
Okay.
There are two parts to that you would have to show this court.
Okay.
For the court to set this aside.
Okay.
All right. The first part of it being that you'd have to show good cause for your failure to appear, which I think you were going to get into. Okay. What I think is more problematic, I think, for you is you have to show this court that there's a meritorious defense to the claim of determination.
Okay. So I had entered into a lease with them. There was some problems with the payment. I think I addressed that in my motion. I have been in contact a little bit with, I believe her name is Michelle from HP. And I believe that we could possibly come to an agreement to allow me to just extend my stay a little bit so that I can get everything out of here. I guess.
Who did you lease from?
HP Foreclosures.
Is that right, counsel?
Your Honor, during the course of the suit, and I do have Ms. Shifter here if you'd like to take testimony, but Ms. Shifter attempted to work out a resolution with Ms. Cheatham to keep her in the property. There was an agreement that if a security deposit was tendered and first month's rent, that they would have this binding lease and that we would ultimately dismiss the case. As you'll see in Ms. Cheatham's unsworn narrative, I guess her husband or spouse absconded with the money, so nothing came of it. My client had attempted to reach out to her on multiple occasions and was largely ignored, and we proceeded. So, effectively, there is no lease, albeit, we tried to work something out with her, but this if I can finish.
Sorry.
This case was filed on December 9th. The redemption, I don't have it in front of me, expired late last year. And now we're here on February 20th, Your Honor. And there's still been no monies produced. So it's our opinion that there is no lease agreement. I mean, my client would not enter into a lease without that.
But I guess, was there signed documents of a lease?
It's my understanding my client did sign the lease, but predicated that the effectiveness of the lease on that payment.
Okay. So I don't have a copy of the lease.
Well, it wasn't a part of this action. It was something that occurred, my understanding, during the course of this matter. When I appeared at the first hearing, I was hopeful, and I even may have put it on the record that the parties—
Well, counsel, here's the problem with that argument. Under paragraph 5F, this action was maintained because of the expiration of the redemption period, but then specifically indicates no tenancy.
Correct, and there was none at the time that the matter was filed, Judge. I'm sure Ms. Cheatham will tell you, and my client representative will tell you, that after this was filed, they were trying to work out a resolution to keep Ms. Cheatham in the—
But then we get into the other issue. So you're saying this signed document, this lease, was entered into after this case was filed?
That's my understanding, yes, Judge.
If the lease happened, after the foreclosure filing. It could create a new legal relationship that changes the court's authority. That's not just a technical, it determines which courts should hear the case at all. The tenant's uncertain memory about dates also matters. Courts rely on precise timelines, not rough guesses. Always. Keep copies, emails, receipts, because in court, proof beats memory every time.
Ma'am, is that correct, Ms. Cheatham?
Yes, if they filed it on December 9th, because I don't,
When did you sign the lease?
I did, sir. I did, Your Honor.
No,
And I am
when?
prepared. Oh, when? It was in January. I don't know the exact date. Might have been like the 9th or something. I'm not quite sure. But I am prepared I have the money to pay them at least the $3,800 today.
Hold on,
Okay.
hold on, stop.
Okay. Okay.
So after this action, both parties signed a document purporting to be a lease. I don't know how there is a conditional lease, but I guess that's what counsel is saying. And Ms. Cheatham is saying that there's a lease. I don't think, counsel, you can argue that there's no lease if both parties sign this document. I don't know how that works.
Well, if I may, just for purpose of nothing else, Your Honor, making a record, there's no consideration. I mean, my client could sign a lease, and if it's predicated, it's our position, it's predicated on payment, like most leases are. And if no security deposit was tendered, no first month, effectively, there's no lease.
No, that's not how tenancy works. I mean, if she's in the premises, you're in the premises, ma'am?
I am, Your Honor.
She'd been in the premises during the whole redemption period, my
I
understanding.
have not. I was in a halfway house. I just got released on January 30th.
Well, we were here before your January 3rd. We were here on January 9th, Your Honor. It was the first hearing, I believe.
Because I'm the executor of the will, so I've been like appearing for court hearings and things like that. But I've been pretty upfront about that. Like when I first came into contact with HP Foreclosure Solutions, that I had just been released from incarceration last July, and I've been in the halfway house since.
Okay, so who's going to send me a copy of this lease or this conditional lease or this thing that one side is purporting not to be a lease, but the other side is saying it's a lease? Because I don't even know how I begin to rule on this without a copy of it.
I don't have a copy. Ms. Cheatham or my client's representative, Ms. Shifter, I could have Ms. Shifter send me a copy, and I could forward it to the court via email, or Ms. Cheatham, I guess, could. I'm sorry, I don't have a copy.
If I may, I'm sending that right now.
Okay.
Michelle Shifter.
I'm sorry, Your Honor.
Let me pass this matter.
Okay, thank you. And
Then it
then
needs to be sent to my staff.
may I have the staff? Can someone put the staff's email in the chat if they don't mind?
She is putting it in there now.
I appreciate it.
Counsel, how are you? I don't know how I get to the point of you saying, when I'm looking at this, that this is not a lease. Parties have all signed this.
A signed lease suggests a legal relationship that might override the foreclosure claim. This shows why evidence is king in court. A single document can flip an argument. And it highlights something important. Foreclosure law and landlord-tenant law intersect in complicated ways. Judges must decide not only who is right, but whether they even have the authority to decide.
Right?
Correct, Judge. As what was sent to me, I reviewed it in anticipation of us going back on the record. It does appear that it's signed. Other than the consideration provided by Ms. Cheatham, before you as well.
And the problem I've got here is that I don't think, quite frankly, that, well, I'll just say it this way, that defendant has a valid lease. And I would submit to you that then the beginning of this case, because of that, this court doesn't have jurisdiction to hear this case. I won't have subject matter jurisdiction under the theory on which this case has been filed. Because you filed it because of the expiration of the redemption period, but at some point a new lease entered in or new interest in property entered in, which I can see. So I don't think, there may be other reasons or a basis upon which this case could then proceed, but I can't proceed as is. I don't think the court has subject matter jurisdiction. When I don't have subject matter jurisdiction over the case, then the only thing I can do is dismiss it.
I anticipated that, Judge Simpson, and I appreciate that. Would you just be inclined to dismiss it without prejudice, and we'll send out the appropriate notices today and get the ball rolling on an appropriate matter before you.
All right, very good. So, Lexa, that dismissal is without prejudice.
And respectfully, thank you for entertaining my argument. I appreciate it.
Not a problem, sir. All right,
Take care,
thank
Your Honor.
you.
You and your staff have a great weekend.
You do the same. You also, Ms. Cheatham.
Thank you, Your Honor. You have a good day.